We actually want to get right to Kara Scannell. Kara, do we have a ruling in the Donald Trump civil fraud trial case?
Yeah, we do, Boris. We just got the ruling. It is 92 pages long, and I'm scanning through it right now. But when I'm looking at these numbers, the totals that the judge is ordering collectively in the case, so this will include all of the defendants, I'm getting a total of $362 million. And I'm just scrolling through this now. I can see that there's the dollar amount specific to Donald Trump. I'm going to use a calculator to do some rough math. It gets us to, for Donald Trump, about $354 million. That's for him, the company, the Trump Organization. So very close to what the New York Attorney General's office was seeking of $370 million. There's a lot of zeros here and a lot of other numbers, but roughly $354 million is the judgment against Donald Trump. The judge also found that his son...
Breaking moment when power meets consequences and everything changes in one courtroom. What you are about to hear is not a routine political dispute, not a minor paperwork issue, and not a harmless misunderstanding. This is the moment when a man positioned to hold one of the most powerful law enforcement roles in America allegedly watched his entire narrative collapse in real time under the weight of judicial scrutiny. According to court proceedings, Cash Patel found himself standing before a federal judge as years of claims, explanations, and legal excuses began to unravel all at once. Was not a quiet correction behind closed doors. This was a public confrontation where authority demanded truth, and the truth refused to stay buried at the center of this storm. Are allegations that Patel repeatedly told Congress that he was legally blocked from releasing sensitive Epstein-related materials because of sealed judicial orders. He reportedly named judges, referenced supposed rulings, and described restrictions that he claimed tied his hands. These statements were used again and again to justify why lawmakers could not see documents they had formally subpoenaed for months. The explanation stalled oversight, delayed accountability, and kept critical evidence locked away. Or so it seemed. The turning point came when a senior federal judge reportedly decided to verify those claims. Judges do not take kindly to having their names invoked falsely, and courts do not tolerate being used as shields for political maneuvering. According to accounts from the hearing, the judge reviewed court dockets, sealed filings, internal records, and communications across the federal judiciary. What emerged from that review, according to the judge, was deeply troubling. There appeared to be no record of any such sealed orders, no matching case numbers, no judicial signatures, and no legal barrier that aligned with what Patel had told Congress. That is when the situation reportedly escalated from oversight dispute to potential criminal exposure. During a tense courtroom session, the judge allegedly confronted Patel, directly presenting transcripts of his congressional testimony alongside court records that contradicted his statements. The contrast was stark. Sworn testimony on one side, documented court reality on the other. Observers described the atmosphere as electric and unforgiving because at that moment explanations ran out. According to those present, Patel was given a clear and immediate ultimatum: comply fully with congressional subpoenas and release all Epstein-related materials by a specific deadline or face criminal contempt proceedings. The judge reportedly made it clear this was not a procedural warning or a symbolic threat. This was real-time accountability with the possibility of arrest. If compliance did not occur, the courtroom reportedly fell silent as the implications sank in. Witnesses later described Patel appearing visibly shaken, stunned, and pale as the weight of moments settled in. His legal team reportedly scrambled, attempting to frame the issue as confusion or miscommunication. But the judge allegedly rejected that narrative, emphasizing that detailed references to specific judges and orders could not plausibly be accidental. The allegation was not that Patel misunderstood the law, but that he deliberately constructed a legal fiction to obstruct congressional oversight. This is where the story shifts from personal peril to national consequence, because the documents at issue are not abstract files. They relate to one of the most notorious criminal investigations in modern history, the Epstein case. These records reportedly include evidence logs, internal communications, and materials connected to public figures whose names have long hovered around unanswered questions. The stakes are enormous because the release of those files could reshape public understanding of who knew what and when. Lawmakers reportedly summoned Patel precisely because of his position and access as the head of federal investigative apparatus. He would have authority over what evidence is preserved, disclosed, or delayed. That power comes with an expectation of Transparency when Congress lawfully demands information according to allegations before the court. Patel did not simply resist. He constructed a legal wall that did not exist and relied on Congress trusting his word. The judge reportedly made it clear that such conduct strikes at the heart of justice system. Courts function on integrity, and when someone invokes judicial authority falsely, it undermines the entire framework. The allegation is not just about misleading lawmakers, but about misusing the credibility of the courts themselves. That is why the judge allegedly described fabrication as dangerous and unacceptable, and why the response was so severe. As the hearing unfolded, it became evident that this was not just about one man, but about a broader pattern of obstruction and loyalty-driven decision-making. Allegations suggest that Patel's refusal to release documents aligned with efforts to shield powerful individuals from scrutiny, particularly surrounding the disappearance of certain materials from public-facing evidence repositories. Lawmakers are reportedly investigating who ordered those deletions and why, and whether political considerations overrode legal obligations. The clock reportedly began ticking loudly toward the deadline set by the judge. Every minute represented a choice: comply and potentially expose damaging truths, or resist and face immediate consequences. The courtroom moment symbolized a rare instance where political influence appeared to meet an immovable judicial boundary. No speeches, no press conferences, no spin could alter the simple demand: comply with the law or face arrest. What makes this moment so explosive is not just the allegation of lying, but the implication of intent. If proven, it suggests a calculated effort to obstruct oversight, protect allies, and manipulate institutional trust. That is why this case has sent shockwaves through Washington, because it challenges the assumption that power can indefinitely delay accountability. As this phase closes, the question hanging in the air is unavoidable. Was this the instant when a carefully maintained cover story finally collapsed? Or was it the opening chapter of a much larger reckoning that will pull more names, more documents, and more truths into the light? The answer depends on what happens next and whether compliance comes before consequences, because when a judge draws a line and says enough, history shows that ignoring it only makes the fall louder. When the LAE expands and the system starts to push back hard, this is the phase where the story stops being about one courtroom confrontation and starts revealing a deeper structure of resistance, concealment, and calculated delay. Because once the judge exposed the absence of any sealed orders, the entire defense strategy collapsed, and what followed was not confusion, but exposure. The alleged fabrication was no longer theoretical. It was documented, traced, and supported by testimony that painted a far more troubling picture than a single false statement. According to information raised during the hearing, the judge did not rely solely on public court dockets. He reportedly examined sealed indices, internal routing logs, and confirmations from multiple judges whose names had been cited in congressional testimony. Each response came back the same: no such orders existed, no such restrictions were issued, and no court had barred the release of the Epstein-related materials. This meant the explanation repeated to Congress over many months had no legal foundation at all. What elevated the situation further was testimony from individuals inside the system. Agents and officials who reportedly worked under Patel told investigators that they were instructed to repeat the same claim when interacting with lawmakers. That detail matters because it suggests coordination rather than confusion. It implies that the story of sealed orders was not a one-time misstatement, but an operational narrative passed down to shield information from oversight. From a legal standpoint, this changes everything. When a senior official allegedly directs others to provide false legal justifications, it opens the door to conspiracy and obstruction allegations. The judge reportedly emphasized this point, making clear that the justice system treats coordinated deception far more seriously than isolated error, especially when that deception interferes with congressional subpoenas, which are a constitutional mechanism, not a political courtesy. At this stage, the courtroom dynamic reportedly shifted from questioning to reckoning. The judge is said to have walked through Patel's prior statements, line by line, matching each claim against verified records. The specificity of those claims was critical. Names of judges, approximate dates, and descriptions of supposed rulings were all cited. That level of detail, according to the court, is inconsistent with an innocent mix-up. It suggests deliberate construction designed to sound authoritative and unchallengeable. The judge reportedly rejected arguments from Patel's legal team that this was a misunderstanding of classification rules or internal policy distinctions. Courts know the difference between classified material and sealed orders, and Congress does too. The problem was not that the documents were sensitive. The problem was that the reason given for withholding them was allegedly false. This is where the Epstein files become central again, because the pressure to conceal them did not arise in a vacuum. These files contain evidence gathered over years. Photos, logs, communications, and records that intersect with powerful names. When certain images were removed from public access, lawmakers began asking who authorized it and why. Those questions led directly to Patel because of his control over investigative records. Rather than invoking executive privilege or seeking a negotiated accommodation, Patel reportedly chose a different route, asserted that judges had prohibited release. This shifted responsibility away from the executive branch and onto the judiciary, making Congress hesitant to push further. At the time, it worked because lawmakers are cautious about interfering with court orders. But once those orders were revealed to be non-existent, the strategy backfired catastrophically. The judge reportedly described this tactic as an abuse of institutional trust. Courts rely on credibility, and when someone falsely claims judicial authority, it forces the system to respond forcefully to protect its integrity. That is why the judge's tone reportedly hardened and why the ultimatum was issued without delay. This was not about politics. This was about defending the rule of law behind the scenes. The implications reportedly began rippling outward. Prosecutors were alerted, oversight committees intensified, coordination and internal reviews accelerated within federal agencies. Morale reportedly suffered because agents expect leadership to uphold the law, not manipulate it. Many are said to be quietly cooperating with investigators, providing documentation, timelines, and internal communications that further illuminate how the fault narrative was maintained. The political dimension also sharpened at this point because Patel's role was not just bureaucratic. He was seen as a loyal enforcer, someone trusted to protect sensitive interests. That loyalty now appeared to be the very thing placing him in jeopardy. The judge reportedly noted that allegiance to individuals does not excuse dishonesty to Congress or the courts, and when loyalty crosses into obstruction, it becomes criminal exposure. As the deadline loomed, the stakes became brutally clear. Compliance would mean releasing documents that could expose deletions directed, and communications involving high-level officials. Non-compliance would mean immediate arrest and detention with criminal contempt charges still pending. Either way, the choice was not between safety and risk, but between different forms of consequence. Observers described the moment as one of visible realization. The protective shield Patel believed existed was gone. The courts were not backing the story. Congress was no longer stalled, and prosecutors were now paying attention. The system that had been delayed was moving again, and it was moving fast. What makes this phase so critical is that it illustrates how quickly power can evaporate once credibility is lost. For months, a single claim held back oversight. Once disproven, it triggered cascading accountability. The judge reportedly made it clear that even late compliance would not erase what had already occurred. Lying under oath and obstructing subpoenas are completed acts not cured by eventual cooperation. As this phase closes, the narrative is no longer about whether documents will be released, but about what those documents will reveal and who else may be implicated. The machinery of accountability has been reactivated, and it rarely stops at one person. When one official falls, others are examined, and when evidence begins to surface, it tends to tell a larger story than anyone intended to reveal. The question now is not whether the truth is coming, but how much damage it will do, and who will be standing when it finally arrives. When the documents become dangerous and the wall of loyalty starts to crack, this is the phase where fear shifts sides, because once the threat of arrest becomes real, the real danger is no longer the courtroom, but the contents of the files themselves. Up to this point, everything revolved around delay, excuses, and legal theater. But now the spotlight turns to what Cash Patel was allegedly trying so desperately to keep hidden, and why the system is suddenly moving with urgency and force. According to investigators, the Epstein-related files are not just historical records. They are a map of who interacted, who communicated, who authorized deletions, and who coordinated responses when public exposure became a threat. These documents reportedly include internal emails, message chains, evidence handling logs, metadata trails, and decision memos that show how sensitive materials treated after Epstein's arrest when pieces of evidence vanished from public repositories. Those actions left fingerprints, and fingerprints lead somewhere. Lawmakers believe these files may establish a direct chain of command showing who ordered what and when. That is the nightmare scenario for anyone involved because it transforms speculation into proof. It is one thing to deny association. It is another thing when internal communications show concern, strategy, and intent. The moment those records surface, narratives collapse and defenses shrink rapidly. What makes this even more explosive is the allegation that Patel did not act alone. Testimony suggests he may have been following directives, or at minimum aligning with a broader effort to contain political damage. That means investigators are not just looking at one individual, but at an ecosystem of protection where loyalty mattered more than legality. In such cases, pressure does not remain isolated. It spreads outward, touching every person who communicated, signed, approved, or remained silent inside federal agencies. The mood reportedly shifted dramatically once leadership credibility falters. Agents and staff begin prioritizing self-preservation. Cooperation increases. Leaks become more frequent, and internal walls weaken. People who once assumed protection realize that loyalty offers no immunity when evidence points inward. That is when cooperation becomes currency and silence becomes risk. This is how major cases expand, not through dramatic confessions, but through quiet calculations. Individuals ask themselves who will take the fall and whether staying quiet is worth the consequences. Prosecutors understand this dynamic and use it strategically. By tightening pressure on one figure, they invite others to step forward. Often with documents of their own. Politically, the situation is turning toxic because the image of a senior law enforcement figure allegedly fabricating legal barriers to protect powerful interests undermines public trust at a foundational level. It reinforces a narrative that justice is manipulated from the top down, and once that perception takes hold, it becomes almost impossible to contain. Opposition figures are already framing the situation as a textbook abuse of power. A loyalist allegedly lying under oath, obstructing Congress, and misusing the authority of the courts to shield elites. That story resonates because it fits a pattern voters recognize. Even supporters grow uneasy when deception becomes undeniable. Fatigue sets in. Defending actions that are difficult to justify erodes enthusiasm and fractures unity. Meanwhile, legal exposure continues to grow. Criminal contempt is only one piece. Lying under oath, obstruction of justice, conspiracy, and potentially subornation of perjury all come into view. If evidence supports the allegations, each carries serious penalties, and together they form a legal storm that does not dissipate easily. Even cooperation may only mitigate, not eliminate consequences. The central dilemma for Patel reportedly becomes impossible to escape, comply and release documents that could implicate allies and superiors, or resist and face immediate detention while still being prosecuted later. Either choice leads to fallout, but one path offers a chance to negotiate while the other leads directly to a cell. Judges are aware of this calculus, and they design ultimatums accordingly. What truly shifts momentum in this phase is inevitability. Once documents are preserved and demanded, their release becomes a matter of time. Courts have the authority to compel production, seize records, and appoint special masters to ensure compliance. Physical custody of documents can be transferred regardless of personal resistance. And once that happens, control is lost forever. This is why observers believe the cover-up phase is ending. Cover-ups rely on control of information. When that control breaks, the truth does not trickle, it floods. Every email references another. Every deletion points to an author. Every meeting note identifies attendees. What begins as one scandal quickly multiplies into several overlapping investigations, each feeding the next. There is also a reputational collapse underway. Power depends on perception. Once a figure is viewed as compromised, others distance themselves. Calls go unanswered. Meetings are canceled. Support evaporates. Isolation sets in, and isolation accelerates cooperation. Because when protection disappears, self-interest takes over. This is how systems correct themselves, not cleanly, not quietly, but through pressure, fractures, and exposure. The judicial branch asserts authority, Congress reclaims oversight, and prosecutors follow evidence wherever it leads. No amount of loyalty, rhetoric can override that process. Once it begins. As this phase closes, one reality becomes clear. The story is no longer about whether Cash Patel misled Congress. The story is about how deep the deception ran, who benefited from it, and how much of the truth was deliberately buried. The documents represent answers, and answers create accountability. The next phase will not be about courtroom drama. It will be about consequences, political, legal, and institutional, because once the files speak, they will speak loudly, and no one involved will be able to pretend they did not know the moment accountability arrives, and nothing can stop. What comes next? This is the final turn where delay collapses, leverage disappears, and the system delivers consequences without hesitation, because once the deadline hits, the story no longer belongs to spin doctors, lawyers, or political allies. It belongs to the law, and the law moves forward whether anyone is ready or not. By this stage, the illusion of control is gone. The court has asserted authority, Congress has reclaimed oversight, and investigators have secured pathways to the evidence, whether through voluntary compliance, seizure, or compelled production. The documents are coming out. That reality alone reshapes everything because it strips away the last protective layer that kept the truth contained. What happens next is predictable to anyone who has watched power unravel. Before once records are released, they do not exist in isolation. Each document connects to another. Each email references prior conversations. Each deletion leaves a trace. Every attempt to hide something creates metadata, and metadata tells a story. That is why cover-ups fail, not because someone talks, but because systems remember. As the Epstein-related files surface, lawmakers will not be looking for shock value. They will be mapping responsibility: who ordered deletions, who approved non-disclosure, who coordinated responses, who repeated false explanations, and who benefited from silence. Those answers matter because they transform scandal into accountability, and accountability into consequence. At that point, political damage becomes unavoidable. Campaign messaging shifts overnight. Public defenses grow quieter. Allies begin distancing themselves. Statements change tone from absolute support to careful neutrality. This is the early signal that loyalty is breaking, because loyalty only holds when it offers protection. Once it becomes a liability, it evaporates fast inside institutions. The correction accelerates. Agents, officials, and staff who stayed quiet out of deference or fear reassess their position. Cooperation increases, information flows expand, and investigators suddenly find doors opening that were previously sealed. This is not betrayal, it is survival, and prosecutors understand this dynamic better than anyone. Legal consequences also compound rapidly. Criminal contempt becomes a starting point, not an endpoint. Referrals for perjury, obstruction, and conspiracy follow sequentially. Each charge builds on the last, creating leverage that did not exist before. Judges, prosecutors, and oversight committees coordinate timelines, ensuring that no single maneuver can stall the process again. The broader implication is devastating for any administration tied to the misconduct, because it reinforces a narrative of systemic abuse rather than isolated error. Voters are not forgiving when they see patterns. They understand instinctively when institutions are being manipulated. And once that perception takes hold, it shapes elections, hearings, and historical judgment. There is also a chilling effect on remaining loyalists. Watching one figure face real consequences forces others to reconsider their own exposure. Silence becomes dangerous. Distance becomes strategy, and cooperation becomes a way out. This is how accountability spreads, not through spectacle, but through pressure applied consistently and lawfully. For Cash Patel, the window for controlling the narrative has closed. Whether he complied at the deadline or resisted, the outcome converges. Documents emerge, investigations expand, and decisions made in secrecy are examined in daylight. That is the cost of using institutions as shields rather than respecting them as boundaries for those higher up. The risk multiplies because evidence rarely stops where it begins. Communications flow upward. Decisions require approval. Strategies are discussed, not invented alone. When investigators follow the paper trail, it leads to rooms where choices were made collectively, and collective decisions create collective exposure. This is why the moment matters beyond one individual. It signals a reassertion of limits, a reminder that no title, no loyalty, and no political alignment places anyone above oversight. When courts draw lines and Congress enforces subpoenas, the system rebalances itself, often painfully but necessarily. History remembers these moments, not for the excuses offered, but for the precedents set. When officials fabricate authority to block accountability, the response defines institutional strength. In this case, the response was swift, firm, and public, and that sends a message far beyond one courtroom. As the dust settles, the long-term consequences begin shaping themselves. Reforms, investigations, resignations, and prosecutions become part of the landscape. Trust must be rebuilt, and that takes time, but the first step is exposure. And exposure has already begun. The truth does not need drama to prevail, it needs access. And now access has been forced. The documents will speak, the records will align, the timelines will form, and accountability will follow, because that is how the system works when it is allowed to work. This is not the end of the story, it is the end of the cover-up. Once that ends, everything else becomes inevitable. And that inevitability is what justice looks like when power finally runs out of places to hide after the storm. When the aftershocks rewrite everything, what follows after accountability is not silence, it is fallout, because when truth finally surfaces, it does not simply correct the record, it reshapes power relationships, careers, alliances, and futures. This is the stage where consequences ripple outward long after the headlines fade, and where the cost of deception becomes permanent. Once documents are in the open, the narrative control is gone. There is no putting evidence back into the dark, no walking back timelines, no erasing metadata, and no unsending messages. Investigators, lawmakers, journalists, and the public all see the same material, and they all draw conclusions independently. It is the most dangerous moment for anyone who relied on confusion to survive. This is when former allies begin rewriting their own stories, carefully distancing themselves, reframing past statements, emphasizing what they did not know rather than what they supported. The language changes from defense damage control, and that shift tells you everything. Loyalty has an expiration date, and it arrives the moment risk outweighs reward. Institutions respond to new safeguards, new oversight mechanisms, new internal reviews are announced, not because reform suddenly became fashionable, but because credibility must be rebuilt when trust is broken at the top. It sends shockwaves downward, forcing systems to prove they can still function with integrity for the public. This moment becomes a reference point. People remember when power was challenged and did not win. They remember when courts drew a line and enforced it, and those memories shape expectations going forward. They create pressure on future officials who now know excuses will be tested and claims will be verified. This is how history turns: a single false narrative exposed, a single courtroom moment amplified, and a single deadline that could not be ignored. From there, the system recalibrates slowly, unevenly, but decisively. The final lesson is simple and unforgiving. Institutions can be bent, but not forever. Truth can be delayed, but not erased. And when accountability finally arrives, it does not ask permission, it just happens.